Hello everyone, good day. I hope you all are doing well. This video presentation is all about litigation. It's for the course SOBI 335, presented by myself, Amisha Mangal, and my group mates Akila Lawrence and Sonia George. With this presentation, we aim to define litigation, explain the litigation process, outline the strengths and limitations of litigation, and apply this knowledge via a litigation scenario. So let's get into it. First and foremost, what is litigation? Litigation is the formal process of taking legal action to resolve a conflict or dispute. Some key elements involved in litigation are a claim, which is an active attempt to attain some valued end result, a dispute, which is a conflict or a resistance to the initial claim filed, and an institution, which is basically the court as a system to resolve the dispute or conflict. There are several types of litigation, including criminal litigation, business litigation, family law litigation, and personal injury litigation, just to name a few. Our scenario depicts personal injury litigation. Personal injury is considered any physical or psychological actions that cause injury, suffering, or harm to another individual. Litigation of this type involves taking legal action in court with the aim of being granted financial compensation for economic losses, hospital bills, vehicular damages, and/or pain and suffering. Even the simplest litigation cases can span 1 year, while more complex cases can go up to about 3 years. However, only a small percentage of cases ever make it to trial. This is because there are other available options. For instance, parties can have a settlement discussion, reach a mutual agreement, and settle a case at any time. There is also the alternative dispute resolution route, consisting of mediation, arbitration, etc., that parties can use to reach a mutual agreement and resolve a case without having to go through a trial. Any person who is injured and seeking justice through the court system is referred to as a plaintiff, whereas the individual or company that has caused the injury or injustice is referred to as the defendant. Now let's look at the litigation process. The first stage of the litigation process is the pleading stage. Here, the plaintiff files a formal complaint to the court that entails all the relevant elements of the situation and allegations against the defendant. Once the complaint is accepted by the court and sent to the defendant has a certain amount of days to respond to the allegations. Different countries have different laws regarding the amount of time the defendant has to respond. However, upon receiving the complaint, the defendant can respond by filing either an answer or a motion to dismiss. If the defendant responds with a motion to dismiss, they are essentially claiming that the allegations brought forward are insufficient or fail to produce a cause of action, and each cause of action reflects a specific legal claim outlined in the complaint. So in a motion to dismiss, the defendant is saying that the cause of actions do not meet the requirements of the law applicable to the plaintiff's claim. The plaintiff usually bears the burden of proof and has to outline the specific proof requirements in the complaint. However, if the defendant files an answer to the plaintiff's complaint, both parties advance to the next stage of the litigation process. Stage 2 of the litigation. Stage 2 of the litigation process is the discovery stage, and this is usually the longest stage. Here, both parties continuously exchange information. Parties can attain and then exchange information via written discovery and depositions. Some written discovery options include request for production, where one party itemizes documents and other information and requests that the other party supplies it. The other party will receive this request and can supply the information. Another method of written discovery is interrogatories, where one party can write questions to the other party, and the other party can respond by answering the questions. There is also request for admissions, where one party writes out statements to the other party, and the other party can then admit or deny the statements received. In terms of depositions, a lawyer will sit and interview a witness following the legal protocols, and both parties are asked to provide the names and information of their expert witnesses. Now we move on to stage 3 of the litigation process, which is the dispositive motion stage. A dispositive motion or motion for summary judgment can end a part of or the entire lawsuit. Typically, when both parties agree on the facts and information gathered during discovery, the only issue that really remains is an issue of law, and a judge is the only person who can resolve issues of law. So one party will file their motion for summary judgment, and the judge can ultimately rule in favor of the motion and dismiss either a part of or the entire lawsuit, believing the motion to be factual. Or the judge can rule that the motion has factual issues and decide that the case will proceed to trial. This brings us to the fourth and final stage of the litigation process, that is, the trial stage. And there are two types of trials. You have the bench trial, where a judge decides the winner of the lawsuit, and a jury trial, of course, where a jury decides the winner of the lawsuit. In either type of trial, both the defendant and the plaintiff will present their case via an opening statement from each side. This is followed by the presentation and interview of witnesses, either by the judge or jury, and then we have a closing. So depending on the type of trial, either a judge or jury will issue a verdict which states whether the plaintiff or defendant won the lawsuit. And this verdict concludes the litigation process. Still, if the plaintiff or defendant is dissatisfied with the ruling and feels as though either the judge or jury has made a mistake, they can file an appeal to a higher court to review and possibly reverse the decision made by the lower court.
Strengths or advantages of litigation. 1. Public record. Because litigation is a legal process, it is conducted through the justice system. For example, the court. Because of this, information is recorded and stored by the government, and the public, you and I, have the legal right to view those information. 2. Cooperation. In scenarios where there are disputes or conflict, cooperation can be difficult to achieve. Litigation requires court-mandated deadlines and requirements, which makes it hard to ignore, thus promoting participation and cooperation. 3. Precedent value. Judgments made in courts carry heavy merit, legal precedents, in other words. They clarify the law and the appropriate decisions for future cases. This means litigants can point to previous ruling in similar cases to bolster their own arguments, and sometimes it allows for a speedier dispute resolution. 4. Appeals. Litigation allows you a course of action if a clear mistake has been made in a previous case. 5. Evidence. Both tangible and intangible information that adds merit to a claim. With litigation, evidence is under strict examination because it is a legal process carried out by the court who constitute what are evidence. 6. Rule of law. Justice for all. Everyone is treated equally. No malice, no choosing of sides because of biases. Everyone is given the fair chance and opportunity to state their case and the right to be heard. Last but not least, results. One of the most obvious benefits of litigation is there is always a result. There is always a legal conclusion. The dispute is always resolved.
Despite the advantages of litigation, there are several limitations. Firstly, litigation is a time-consuming process. If you recall, we mentioned earlier that simple litigation cases can go up to about 1 year, and more complex cases can go up to about 3 years. So depending on the nature of the lawsuit and the preferred end goal of the plaintiff, the litigation process can be disadvantageous because both parties have to wait a significant time to hear a verdict and conclude the matter. The litigation process is also costly. Not only are there legal fees associated with the court system, but there are also attorney representative fees, and the longer it takes to resolve a lawsuit, the higher the litigation costs. Of course, this is disadvantageous to many who are not financially able. Because legal documents are in the public domain, lawsuits can attract public attention. This can be disadvantageous to companies, socialites, and even the everyday citizen, especially if the nature of the lawsuit is unsettling and they are uncomfortable with the matter being publicly accessible. Lastly, the litigation process can be damaging to relationships, whether it be personal, professional, or otherwise. During and after the trial process, it can be difficult to overcome animosity, and both parties may struggle to preserve any sort of relationship after hearing the verdict. These are the references. Maria and her family went to grocery shop at the Shop for Less supermarket, where she went down one of the aisles in search of some items. Unbeknownst to her, the floor had just been mopped, and unfortunately, she slipped and fell, and all her items scattered on the floor. She made many attempts to get up, but was unable to do so. However, another customer came to her aid and helped her to her feet. The customer then assisted her to the manager's desk so that she could lodge a complaint, as she believed that her fall and the resulting severe back and neck pains were the company's fault. Whilst at the desk, Maria informed the manager about the incident, and she became very angry when the manager told her that unfortunately there was nothing the supermarket could do to compensate her at this time. The manager also said that Maria should have worn proper footwear to come into the grocery. Maria gathered the members of her family and left the establishment disappointed. She was advised to seek legal redress in this matter, so she visited her lawyer's office. Maria received the necessary advice and filed a formal complaint against Shop for Less supermarket. This initiates the pleading stage. Shop for Less supermarket answered this claim, but reiterated that it was no fault of their own for Maria's mishap and that she would have to cover her own medical expenses. This ends the pleading stage with Maria as the plaintiff and Shop for Less supermarket as the defendant. Together with her attorney, Maria submitted a written request to the defendant in the form of a request for admissions. The request for admissions detailed that there should have been a proper and visible sign in place for customers to be aware of the wet, slippery, and unsafe area. Another request for admissions detailed that the type of tiles placed on the floor were unsuitable and the grocery should take full responsibility. The defendant responded by denying all statements and claims. The obtainment and exchange of information ends the discovery stage as all the required documentation and evidence have been gathered. The plaintiff filed a dispositive motion, but the judge stated that there were factual inconsistencies and determined that a trial was needed. The judge's ruling ends the dispositive motion stage. At a bench trial, both the plaintiff and the defendant put forward their case, but the judge's verdict was in favor of Maria. Shop for Less supermarket has to compensate Maria for all medical expenses, loss of income, and hardship for a period of 8 months.